We'll call the meeting of Jelcar for May 20th to order. Having 9 members present, we have a quorum. Looking for a motion on the minutes. Motion to approve by Schmidt, second by Lang. Any additions, deletions, or corrections to the minutes? Seeing none, all in favor?
Aye.
Any opposed? For a motion on the consent agenda, does anybody wish anything removed from the consent agenda? Seeing none.
Consent calendar.
Second.
Motion by Gray, second by McGuire to approve the consent agenda. All those in favor?
Aye.
Opposed? The consent agenda.
There's a number of alternates here that.
Mr. Chairman,
Yes.
Representative Tucker could sit for Senator Prentice, and Representative Gruen could sit for Representative Hatch.
Okay, we'll adopt that suggestion from the director. And the Department of Health and Human Services has not answered their preliminary objection.
That is correct. We
OPLC,
anticipate it for next meeting.
OPLC,
Hey, yes, sir. This proposal makes changes to the licensing rules for these types of practitioners. There are a couple of issues to bring to the committee's attention. The first one is on page 10 of the linked PDF. There's a comment regarding the fact that the rules have been expired since 2018. Authority for the administration of these professions transferred from the Department of Health and Human Services to the OPLC in 2015. And like I said, the rules expired it transferred in 2015, and the rules have been expired since 2018. So the committee may have some questions about how licensing applications and fees have been handled during that time period. If you want, I can go ahead and go through the remaining comments, or we can turn it over.
I
for
think I'd like
questions.
to hear from the agency on this.
Good morning, Lindsay Corney, Executive Director, Office of Professional Licensure and Certification. I think, as the committee is no doubt aware, the OPLC has had some deficiencies in the rulemaking process that I think we've corrected with the addition of staff and trying to establish internal controls, which is why we were able to promulgate rules for reflexology recently through this proposal. I will say, I think there's about 60 licensed reflexologists. I'm not aware of recent applications that we've received that we have attempted to enforce rules. Obviously, without rules in place, those are not enforceable, so we would just adhere to the statutory requirements.
Excuse me, thank you, Mr. Chair. Do you have could you report on how many expired rules you're suffering under at the moment?
So we do have a tracking sheet in place. My understanding is that, and Tina can correct me if I'm wrong, we're pretty up to date right now. We have a couple of rules for various boards slated to expire in June, but I think they are underway. Rulemaking is underway. Go ahead.
With regards to expired rules, we do have a couple of boards that have expired rules that we're working on to get before JLCAR as soon as possible. And we're working with the boards as quickly as possible to get those done.
Well, one of the concerns that those senior members of JLCAR have, and Representative McGuire and I and Senator Reagan have worked diligently to make the agencies aware that expired rules are not rules. They don't mean anything. Supreme Court ruled that way, and then there was a statute passed about, what, 6 years ago or so, to make the same statement in statute that we can't be having situations with expired rules out there. So we are very concerned about what has happened. I hear this about since 2018, 4 years ago. And so we're very concerned about what has been going on with those agencies and departments that have expired rules.
Thank you, Representative. I completely share your concern, and I will give you an example of something that came up recently with the vet board. The vet board has been working on rules since it was transferred from agriculture back in, I think, 2019 when I first came on board. They had a rulemaking proposal in process, never finished it, in part because I think they couldn't make any decisions. And so therefore their rules expired related to continuing education. We had advised them very recently that they couldn't enforce those continuing education requirements, which they are aware of. And I understand a proposal is before you, but part of the issue is that while OPLC can provide administrative support, which obviously has been deficient in the past, we cannot require the boards to make decisions, and we cannot require them to convene a quorum to actually move the rules forward. Reflexology is different because it's an advisory board, and it absolutely should have been done sooner than today. But I do think that we've made the necessary corrections internally to make sure that that doesn't happen again.
So now's the time of year to start proposing legislation.
We have a running list, Senator.
Okay.
Okay, the next issue to bring to your attention is on page 13 of the linked PDF. And this is a note regarding the fact that the OPLC has filed some rulemaking to address fees in PLC 1002. You may recall that this issue has come up previously, that some of the board rules have been citing to non-existent fees at PLC 1002. And so this was just to let you know that the OPLC has filed rulemaking to address that concern. The next issue is on page 15 of the linked PDF, and it's a minor editorial issue. It just where the forms and the rule text aren't really lining up. Like I said, they're very minor. The form says mailing address, whereas the rule text says billing address. And there's just a minor difference in the attestation, where here in the rule text it says rules, but on the form it says regulation. So, and then finally, there is one more issue on page 19 of the linked PDF. Just scrolling down there. This one is around the cap. So there is, this is about the fees and the fines. The statute has a cap of $2,000, and some of these fines would hit that cap during the first month of noncompliance. The rule doesn't talk about doesn't address this concern at all, doesn't talk about the cap. So this could be fixed by having some language in the rule that clearly states that there is a $2,000 cap. Other than that, those are the remaining issues with this proposal.
I think, thank you, Mr. Chair. I think that the clarifying that there is a statutory limit of $2,000, you could even put that up under D as part of the top heading for the whole fine schedule. In fact, I would move that we conditionally approve it, provided that, you know, it's instead of the semicolon, say, comma, up to a limit of $2,000 per licensee, I think is whatever.
Or not to exceed 2,000?
Not to exceed 2,000, that would be fine.
The agency has no objection to that. We can certainly make that change.
Motion for approval by McGuire, second by Gray. Any discussion? All those in favor?
Aye.
Any opposed? And the rule carries. Pharmacy Board.
Okay, so this proposal makes changes to the standards of practice for pharmacists, pharmacies, manufacturers, and distributors licensed by the board. This item was postponed from the previous meeting, that was to allow the OPLC to work with the board on a conditional approval request, and one has been filed, and it does address the majority of the issues. There are a few still left to discuss. The first one begins on page 5 of the linked PDF. There's a note here down at the bottom of the page that there's a large section here that's being repealed. I don't think that they've entered into any rulemaking to put this, section somewhere else in another pharmacy rule. But this was to bring to your attention, and because once repealed, that section can't be enforced. And so the committee may have some questions about the reasons and intent behind repealing this section. I can move on to the other ones if you like.
Sure.
Okay. The next one, I'll just scroll down. It is on page 10 of the linked PDF. And here, this is just a clarity issue. The website there doesn't actually have the controlled drug loss form. So that's why the comment is there. There's also a note down at the bottom of the page to let you know that the agency deleted a section on automated data processing systems, but that section is now part of another rulemaking. The last issue involves comments on the next page and on page, I believe, 20 of the linked PDF. And what this is about is that the rule says that permit holders need to have a current written break policy for when the pharmacist in charge goes on break. And the statute also requires that there be rules in place around that issue. To specifically have a policy for the supervision of interns, as well as policy and procedures for when a pharmacist goes on break. But the proposal has repealed that section, and so it's not entirely clear why that's being repealed or whether or not that's going to be part of another rulemaking to address that statutory requirement. And that's it.
Good morning, I'm Tina Kelly with the Office of Professional Licensure and Certification. So to address the first issue on page 4, the repeal of the larger section, those rules are actually been moved to institutional pharmacy practices under PH 2300, and that has been adopted. So everything from area sinks, water, size of facility, all of that is addressed there. On the next one is the issue of the website. The form will be put on the website as soon as it's approved and the board adopts these rules, because I'm not sure with the first forms, but we're trying to get all the forms into rule, know that those are the ones that are being used. So the one that you've got is the one that will be posted as soon as this is adopted. The next one is the issue of supervision of interns and breaks. That is all addressed in PH 303.02. What the Pharmacy Board is trying to do with the changes to all of these rules was to move things into different places where they made more sense, address things in the appropriate areas. So that is why you're seeing entire sections being removed, put other places. And they're trying to address, most of the time these rules were old, so they address pretty much sole proprietors. Now we have a lot of corporations and that type, so they're trying to make these more inclusive, so anybody, whether it's a sole proprietor or a corporation, can all follow the same set of rules. So that's the goal, but that is addressed in 303.02. Did I cover everything?
All good? Motion. Peter?
I have a question, Mr. Chair. So, we had a situation 4 or 5 years ago, which I think you're probably aware of, Tina, you've been around that longer than that even, with regard to breaks, especially for chain pharmacists. And we know we had a lot of testimony with regard to the error rate going up. The longer people don't have a break, especially a lunch break, and people working sometimes 12 and 13 hours with no breaks. And that was, the pharmacy board was trying to do something about that. There was a lot of pushback of whether they had the statutory authority, whether the, pharmacy board did or not. So what is the current situation there?
So I believe under 303.02, which I do not have in front of me, so I'm speaking from what I've talking to the board member yesterday, was that those types of things are addressed there so that there are limits on the amount of hours a pharmacist can work without a break or and things like that. That's all in 303.02. So even though it's been removed from here, it has been put into another section that should address all of those concerns.
Okay,
I'm okay, yeah.
okay. You're still on. Your microphone's still on. Your microphone's still on.
Sorry.
Still on. Yes.
Yes, I see that in 70301, it does require a rest every no more than 8 hours. Is that compatible with stricter than or less strict than the rules in the other rules that you referred to?
I would have to look that up. I am not sure. I think sorry. I believe they tried to stay consistent, put it in areas where it would be more applicable. And without looking back in that, I can't give you a definitive answer.
Okay.
Excuse me, Tina, you said it was in 303?
Yeah, that's what the board member that I spoke to yesterday.
Yeah, I don't see it, and I've looked in our database, and I'm not seeing any recent rulemaking around the issue, so I don't know.
Tina, when was the other one adopted?
That I'm not sure of. Like I said, I talked, the board members do a lot of their drafting. So I talked to one of the board members yesterday who provided me with the information as I brought it up with the comments.
Okay.
We can look that up and find you the answer and give you a comparison of the two rules.
Okay,
Fine, I move to approve the rule with the proviso that the agency and the staff confirm that this is compatible with other rules.
Second, okay.
motion by McGuire, second by Schmidt. Any discussion? All those in favor?
Aye.
Any opposed? Occupational therapists.
Okay, this proposal makes changes to the rules for licensing of occupational therapists, and the proposal was postponed from the last meeting because the rule contains a citation to an allied health rule for the fees. But the allied health rule indicates in the introductory section of that rule that the schedule of fees is for speech language pathologists and not for all allied health professions. So because the issue has come up several times, the committee wanted to postpone to allow OPLC to work with the board to find out whether or not the board intended to enter into rulemaking to address that piece of the allied health rule.
So the Board of Directors of the Office of Licensed Allied Health Professionals met on 5/12, and I gave them proposed language to list all of the boards within Allied Health, so that it was very clear that the fees apply to all the boards, and they have approved that. There was one other fee that they wanted to wait, and that's something completely different. And it's pending the addition of hearing care providers. So we just have to get that on that one rule, one fee, the approval of the speech board. Once that's done, I'll be filing rulemaking.
Okay. That's everything?
That's everything, sir.
Motion?
Move to approve.
Motion by McGuire, second by Burstein. Any discussion? All those in favor?
Aye.
Any opposed? Passenger Tramway
Thank you.
Safety Board.
Mr. Chairman,
Yes,
the vote that just occurred, that was a conditional approval of
Yeah.
the rule.
yes.
This is passenger tramway safety rules. There are several clarity and legislative intent comments, mainly with regards to the forms mentioned in the rules, because they've not been filed yet with the committee staff for review. Excuse me. And there was a issue, excuse me. There was an issue brought to the committee staff attention after the comments were finished regarding the possible creation of licenses which may cause a lack of authority comment. However, I believe the agency is prepared to take a preliminary objection so that we can have time to work these issues out.
That works.
Fine, in that case, I move to object to the rule on the grounds that it creates actually 2 new licenses at least. I'm not sure if there's more, but there are at least 2 new licenses that are defined in the rule.
Second.
So your objection would be based on staff comments and on the possible lack of authority for the licenses?
Yes,
Yeah.
541A requires explicit authority to create a license, and I don't believe they have it.
No, I was just asking if you wanted to include my other comments.
Why
staff
not?
Comments. Okay.
Okay, we have a motion and a second. Any discussion? Are you clear on what's missing?
There we go. Sorry. Good morning. My name's Marta Moltiani. I've been working with the Passenger Tramway Safety Board with their rulemaking. The forms we did provide to OLS, and I think that a lot of the comments we can address. The board is next meeting in June, so I believe that most of the staff comments can be addressed satisfactorily to the board. With regards to the most recent one, I don't believe that we necessarily agree that the board is creating a license, because the board is given the authority to incorporate the standards in order to regulate the ski areas. And the board has incorporated by reference the ANSI standard, which you have in your meeting packet, which does reference the qualified wire inspectors. And therefore, I'm not sure that we'll be able to address it satisfactorily to the committee, but we might be able to explain it.
I would have to agree with the agency. Marta's correct. It's unclear if there is a license to committee staff as well, but the preliminary objection will give us time to look into that and determine if it, and explain the situation to you and make sure that there isn't a license being
Well,
created.
If you look at the bottom of page 7, it says qualified wire rope inspector means an individual who is acceptable to the board to inspect wire ropes. That says that any person who is inspecting wire ropes must be given approval by the board.
I agree.
And whereas if you want to say that it's a person who has been qualified according to federal standards or national standards, that's something different. But you're changing from the owner of the wire as picking somebody to do the inspection to saying that the board has to approve such a person, and that means it's a license.
Yes, I agree. The rule does incorporate some I believe it's federal information, and the statute is quite vague. So that's what I'm saying. I need some more time to look
Fine.
through that so I can explain it better.
Okay? I'm agreeable with that.
Okay, and you, sir, please tell us who you are.
Hi, my name is Briggs Lockwood, and I am the Chief Tramway Inspector for the New Hampshire Department of Safety. I apologize for being late.
Can you shed any light on the wire
I'm
inspector?
not sure exactly what you've been speaking about, but, the standard that we've adopted for years requires that, a wire rope expert inspects the wire ropes annually. And since the beginning, when New Hampshire first made, had an RSA that was passed in 1960, New Hampshire is required that the person who claims to be an expert shall submit their credentials to the board, and the board would approve them and put them on a list. So that, as far as I know, there hasn't been any change to the way we've been doing that since the early days before my time. So I think I'm not sure I understand what the question is procedurally, but I think nothing seems to, in my view, has changed. We still require that if a person wants to be considered an expert to inspect wire ropes in New Hampshire, they submit their credentials, the Tramway board reviews them, approves them, and puts them on a list.
And who issues the credentials?
The person brings those, there's a list of requirements in our rules that say the board shall approve them if they bring in, if you've got, I don't have the rules in front of me, 5 years experience, or there's a list of things that are required. So many inspections completed, how many years experience, a letter of recommendation from a wire rope manufacturer. Person brings those to the board reviews them and says, yep, you're on board.
Sure sounds like a license to me.
Mike?
In 1985 and 86, I was a legal intern at the Department of Safety and reviewed rules, and including passenger tramway, and that was the process at that time.
But I believe at that time, 541A did not explicitly require that every license be statutorily authorized.
I believe you're correct.
Yes.
It seems like we've defined the issue, and with the preliminary objection, I think it's time for the department to take action during the period of time until this comes up the next.
Okay, in the interim, y'all work out if there's anybody that even issues a license. So,
There's no other entity that I know of. We could do it ourselves as a state, I think.
well, that's what we're questioning, if we need to establish the license. Okay. So,
So you have a motion for preliminary objection, and I believe there was a second, although I don't know who the second was. It was Representative Lang.
okay.
It was Representative Burstein.
No.
Oh, okay.
Yeah, it was Lang. Okay, any further discussion? Edith?
I just want to make sure that as we're looking at these, we are aware that there are more tramways now, unless this is defined as at Cannon Mountain. There seem to be trams at Omni Mount Washington, other places.
Right, I think that we're talking about all ski lifts when we call Tramway, so.
All ski lifts.
Right, so the number's pretty stable, there's construction seasons like this one that are pretty busy, but if you looked at it over a long period of time, I think we aren't seeing a big increase, but there's 175 or so of them right now. It's been that way for a while.
Great. Thank you very much.
Okay, you've heard the discussion. All those in favor?
Aye.
Any opposed? Department of Safety.
All right, this rule is an interim rule regarding EMS letters of concern. And it was filed as a result of Chapter 205 of the laws of 2021, which allows the the commissioner, to issue a letter of concern in lieu of a license suspension. The only substantive comment is on page 4 of the rule text. And the concern is that the text states that a suspension may be deferred or may be rescinded, and this language allows for oral rulemaking because of the lack of criteria for when these would or would not happen. However, even though the current language is unclear and causes a legislative intent issue, this is an interim rule, and so these issues could be fixed when the agency goes to regular rulemaking. That process, because interim rules only last for 180 days.
Move to approve the interim rule.
Motion by Lang, second by McGuire to approve the interim rule. Discussion? Seeing none, all those in favor?
Aye.
Any opposed? Department of Environmental Services.
Okay, so this is air-related standards for new and modified facilities for air pollutants. The proposal makes changes to the rules for those standards, and it impacts municipal solid waste landfills. There is one issue to discuss, which you'll see on the top of the page on page 7 of the linked PDF. The state has a delegation agreement with the EPA, and the rule is being updated to incorporate new and revised EPA standards promulgated since 2017. There should be also a linked agency response to comments, and in that document, the agency states that the standards are already in place and essentially that they're already in effect, and so the proposal doesn't impose any new requirements on any existing sources in the state. So that's the issue, and the department, may be able to explain that a little more.
Yes.
Mr. Chair, I find it disingenuous of the agency to say that we've been incorporating these standards for the last 2 years and therefore it's not a new requirement. It's a new requirement since the last time the rules were updated, if I understand you correctly. And therefore it's a new requirement.
Like I said, I think that the agency can explain a little more. My understanding is that it's already a standard, that a lot of the standards were already industry-wide, but like I said, Pam Monroe is here and can probably answer your questions.
Pam Monroe for Environmental Services. So what happens is EPA promulgates these what are called emission guidelines, and that's the 2014 date is the date of the promulgation. And so any source that is in existence at that time is an existing source. Then there's a process by which the EPA promulgates a federal plan. The federal plan then makes those emission guidelines enforceable. That federal plan was litigated at the federal level, and it went into effect in June of 2021. So in order for the department now, so the existing sources are subject to the federal requirements now. The department has always taken the approach that we want to regulate New Hampshire sources instead of them having to deal with EPA. So the plan went into effect in June of 2021. This action will incorporate by reference the federal standards, the federal plan, so that the state can now enforce the requirements with New Hampshire sources, to work with them to comply with the standards. And I apologize if our papers weren't clear enough on that. So,
Well, if you want to say that the requirement is due to, it's a new requirement in the rule. If you say it's due to the federal requirements which you have adopted, that's one thing, but it's, you cannot, our Constitution forbids us from just casually adopting federal rules or regulations that have not been approved by the legislature or its delegates, namely JELCAR. So you can't just say to everybody, okay, there's a new federal federal requirement that everybody has to agree to. You have to come to it with rulemaking, and it is, in the rule, it's a new requirement.
That's exactly why we're here. This action, so currently, these sources are subject to federal requirements. EPA can enforce those federal requirements against sources in New Hampshire that are subject to them. This action, we're coming before you to adopt those standards so that the state can enforce them. You're correct. We cannot do that now.
Thank you.
That's a useful clarification.
Okay. So, motion,
I move to approve. I think that she explained.
second. Motion by Schmidt, second by Senator Whitley. Discussion. All those in favor?
Aye.
Any opposed? Okay.
All right, the next is Board of Education, the Learn Everywhere program. It's 2021-133. Excuse me. The conditional approval request for this proposal has eliminated all but one comment, and the comment appears on the last page and deals with text on page 8 of the rule. It's ED 1407.02A. The text reads as follows. It says, notwithstanding ED 306, schools shall accept at least 1/3 and may accept as much as 100% if approved by the superintendent of the total number of credits required for high school graduation if requested by a student pursuant to see below. Now, this, some of you may remember, has come around before. So in 2019, the JLCAR voted 6-4 to do a final objection to what was then 2019-5 on the same rule. The objections were based on legislative intent and beyond a lack of authority of the board. The JLCAR also voted to do 6-4, voted for a joint resolution, which went back to the Senate to clarify the authority of the board. That was Senate Joint Resolution 1 during the 2020 legislative session. It was voted ought to pass in the Senate, and it was laid on the table in the House where it died. After that, the agency was allowed to promulgate the rule, which they did over in August of 2020. It was adopted over a final objection, which means that currently the burden of proof is on the board to establish that the part objected to is within the authority delegated. At this time, that final objection still stands. And as far as JLCAR staff knows, there have been no challenges in a court or in any way of this rule that was objected to. And so essentially it's the same language. And as I maintained the last time this came around, there may be an issue of lack of authority and there may be an issue of legislative intent. That is up to the JLCAR to determine. And you can now at this time either do a preliminary objection, issue a conditional approval if you have specific language that you want to change, or you may vote to approve the rule. If you approve the rule, this would take away the final objection from before and flip the burden of proof back onto the plaintiff, which is what your objection and approval does. So if the agency would like to discuss as well, but I know some of you remember this was the same issue from before. So if you have any questions you want me to explain more, I can, because I know not all of you were here last time.
Mr. Chair, I want to move a preliminary objection because of the all the issues that were just raised. Nothing has changed since 2019. So I would be interested to hear why nothing has changed since 2019, but I want to move a preliminary objection based on the comments that the staff made. Thank you.
Welcome, Commissioner and other guy.
For the record, Chris Bond, Senior Assistant Attorney General, here on behalf of the Department of Education.
Okay. And identifiers.
Great. So did you want me to respond to the comments? I wasn't sure if there was a question, specific question in there or
No, I
not.
just made the motion. Thank you.
Yeah.
Okay. So you heard the staff comments and you're here to answer. Go ahead.
Is there a motion that you're responding to, or do you want me to respond?
So I made the motion based on the fact that what we have in front of us is exactly the same as what we saw in 2019. And you know, the procedural things that happened after that. So I'm curious, even though there was a final objection and everything that happened, why there isn't anything different about the rules that are before us.
Yeah, so we made.
Excuse me, Commissioner. Mr. Chair, we have a motion with no second. Without a second, the motion dies.
Second.
I second.
Great, so thank you. So what has happened since we were here before JELCAR previously is that we have implemented the program. So we now have 15 Learn Everywhere programs that have been approved in the state. And you have students who are engaging in instructional materials. In fact, I was on a phone call before I came in of students who have completed a program at the New Hampshire Institutes of Science in order to earn credits. And so we are moving forward with the program as it is. And as we began the implementation of that program, we saw there were some technical fixes in the rules that we wanted to do. So we're bringing this rule before the body for that purpose. We believe in the letter that was provided to you in the package of information that we have addressed the JELCAR concerns that have been raised. And you will notice that the JELCAR attorneys were very precise in their language. They said there may have been a concern. We believe there is not a constitutional problem. There is not a rule problem associated with this, and that these rules should be adopted.
Follow up?
Go ahead.
I just wanted to ask the JELCAR staff if you believe that all the your concerns were addressed.
So my purpose is not to make the determination of a judge in a court of law. So I can say that there may be a lack of authority and there may be issues of legislative intent issues, but I cannot definitively answer that. It's up to the JELCAR to determine that.
Representative McGuire.
Yes, thank you. I'd like to ask the commissioner if he has taken any steps to obtain legislative clarification of this issue.
So there was a bill that was in the House. I don't know what the status of it is right now. That was continuing to further clarify the legislation towards the initial and original intent. I
Mr.
do
Chair.
not. I do know that Representative Ladd was the sponsor of the bill.
Just a point of clarification so I can understand exactly what we're talking about. The issue revolving that we're discussing right now is basically whether or not the Board of Education has the authority to say that 1/3 of the credits shall be granted may be granted through at a request of a student may be granted towards graduation, and whether or not they have that authority, if that authority of granting credit solely and strictly relies amongst the school board or a school district. Is that my understanding of this conversation?
That's correct. The issue was whether or not the board could mandate 1/3 be taken by be accepted by the schools because the statute appears that it may have separated out those authorities, part of it to the school boards and part of it to the agency, the Board of Education. And that was the question of where does that line lie?
And so we had addressed that issue, and we continue to assert that when you read the statute where it talks about relative to the approval of alternative programs for granting credit leading to graduation, that that ability to grant credit leading to graduation does vest the authority in the board. As well, the letter that was laid out to you, as well as the testimony that was previously provided and the legislative history on this demonstrates, in fact, that that was the original intent of that bill and is receiving further clarification through the legislative process.
Mr. Chair. Thank
Yes.
you, Mr. Chair. So I'm just going back to JELCAR's staff comments, it's more than just the authority. If you look on their comments, there's a problem that they have, a potential problem that they think that it's contrary to legislative intent in two different ways. So it's both, my motion for a preliminary injunction is based on two different potential bases. I mean, we only need one, and there are two here. The fact that the authority was exceeded and that it's contrary to legislative intent. So we have two out of the potential four bases. In fact, we only need one. So that's the basis of my motion. Thank you.
Do you want to, well, so what I would tell you is that we've responded to the other objection as well. I was responding to Representative Lang's question specifically, but we have addressed both of those objections.
Go ahead.
Yes, I noticed that was House Bill 1329, which was voted on the consent unanimously by the Education Committee to be killed because the state board has rules, which says that they aren't going to, yeah, well, that's the legislative intent, that we don't need the law because we have rules, which I'm sorry I didn't notice it at the time, but it was
If I may,
backwards.
Go ahead.
I just wanted to reiterate that the department's position is that the legislation is clear and the intent is clear. Obviously, that we don't agree with the OLS staff on that point, but I just want to read the language of RSA 193E2A, Roman numeral 5B. It says the State Board of Education shall adopt rules pursuant to RSA 541A relative to the approval of alternative programs for granting credit leading to graduation. So I assume hearing that the reference to the state board has rules might have been a reference to that statutory authority that gives the board the authority to do that.
Right, and the original confusion was because of the paragraph before that and reading the language of the statute together. Again, greater minds have differed over clearer things, so.
Okay, we have a motion from Senator Whitley. Would you restate you object?
Thank you, Mr. Chair. Yep, so I move a preliminary injunction based on the significant issues raised by the OLL staff, who, as we all know, are, the most conscientious folks, I believe, in the State House. And, I just want to say, of course, I recognize that students learn differently, but I also think that it's important for schools to, retain local control over what learning counts towards graduation credit. So hopefully the department will work with OLS staff to address the concerns that have been raised, 3 years ago. There's been ample time to do that. So hopefully this preliminary objection based on two different bases. Again, there are four potential bases. We have two here. So I do feel like it is our obligation under our authority, the jail card's authority under the statute to issue this preliminary injunction and let them, work together to get a product that really works for everyone. Thanks.
Further discussion. Tim?
Thank you, Mr. Chair. Again, I think Section 5B is extremely clear when it says the word shall adopt rules relative to the approval of alternative programs for granting credit leading to graduation. So that clearly gives the agency rulemaking authority to set some parameters. I think they were conservative in choosing 1/3 as the minimum standard. So I'm going to be voting against this motion.
Any other discussion? Seeing none, we'll do a roll call vote on Senator Whitley's motion. Edith? Yes. Tim?
No. No.
No.
Peter Schmidt?
Aye. Yes.
No.
The chair votes no. Senator Ward?
No.
Senator? And Senator Whitley?
Yes.
Yes. Okay, the motion fails.
Mr. Chair, move to approve.
Second.
Discussion on the motion to approve.
Mr. Chair, thank you. I mean, I think this is doing a big disservice to the many attorneys on the jail car staff. I mean, I respect your analysis, but I would always defer. I'm a lawyer myself, but even in this case, I would defer to our staff. All lawyers, all went to law school, are telling us there's problems. So I'm really sad to see this. I think this really interferes with the credibility of jail car that we're doing this.
Further discussion. Peter?
The fact that it has not been adjudicated, I think, leaves the matter up in the air in my mind as well. The fact that it hasn't been challenged is, you know, the argument that Senator Whitley enunciated a while back has merit in this particular situation, I think, because to the degree that there was an objection to begin with, and that it has not been adjudicated, leaves it up in the air. And I would have preferred if the committee, if the Board of Education had come back to us with, the Department of Education had come back to us with some recognition and acceptance of that and some change. So I think it still leaves it up in the air, and it has not been adjudicated. So I don't think it's resolved. And jail car staff is competent legal authority. I'm going to go with that. Thank you.
Representative McGuire.
Yes, thank you. I'm actually more concerned that the agency apparently was working with the chair of the Education Committee to clarify this so that it's not a conflict, and they decided that it wasn't necessary because it's in the rule. And I think we need to train our committee chairs better so that they know that the rule does not trump the law.
Committee staff is actually working on some of those trainings to do just that.
Thank you.
Any other discussion? Representative Tucker. Blaine?
Yes.
Yes. Yes.
No.
Yes.
Chair votes yes. Senator?
Yes.
No.
Okay, that motion to approve carries 7-3. Do we have any other business to come before the committee? If not,
Mr. Chair, we might want to reschedule next month's meeting.
okay. Mike?
That was what I was going to speak to. For the newer committee members, traditionally, JELCAR has met on Fridays, the third Friday for the first half of the year during session, and then on the third Thursday, the remainder of the year. This year's session is ending somewhat early, and there should not be many meetings in June, so there was interest in moving the June meeting to Thursday. However, since the committee had voted on its schedule at the beginning of the year, I think it would take a motion and a vote.
Well,
So
do
move.
so
Second.
Motion is to move the June meeting from Friday to Thursday. All in favor?
Aye.
Any opposed? And we'll cancel the continued meeting.
So that will make the next meeting on June 16th, Thursday.
Okay,
We are adjourned before the bagpipes.
all right. Thank you for beating the bagpipe deadline.
Was there an adjournment? Was there an adjournment?
Yes, Carol beat me to it.